Good morning, everyone. We are recording. Today is Wednesday, February 23rd, 2022. This is a public deliberation before the Baltimore County Board of Appeals in case number 21105 SPHXA in the matter of St. Rita's Roman Catholic Congregation and Family Crisis Center of Baltimore for a property located at 2907 Dunleer Road in Dundalk. My name is Deborah Dobkin. With me are board members Joseph Evans and Adam Sampson. This deliberation is being held virtually because of the coronavirus shutdown. As you may recall, there was a hearing scheduled on November 18th and 23rd regarding this property, which is a city block comprised of 5 existing buildings, all of which were built close to 100 years ago. The primary building is the St. Rita's Roman Catholic Church and an adjoining rectory building. And these front on Dunman Way, and behind them is an 2-story school building, a convent, and an existing church hall. And all of these buildings are existing at this time. I believe we have a number of issues before us, and they fall into, I think, 4 categories: the zoning special hearing, zoning variances, a zoning special exception, and additional zoning variances. The church has divided these into lots 1 and 2 for purposes of distinguishing the relief requested. And I think the best way for perhaps us to look at these is to consider the relief that relates to the existing buildings and the existing uses, and to look then at the proposed change in use and the modifications to the buildings where those uses are proposed, unless you see it differently.
Good with that?
Okay. Then, as St. Rita's has proposed it, lot 1 is the parcel on which the existing church and rectory building are located. And the relief that they have asked involve, for the church, to confirm that the existing buildings are not subject to the RTA, or to grant an exception to the RTA, and to permit the existing rectory within the RTA buffer and setback as a non-conforming use. Also, they asked for some parking determinations and an alternative approval for a special exception. Not on lot 1. Let's stick to lot 1. Your thoughts, Mr. Evans, as to lot 1, non-conforming use, RTA applicability.
Yeah, so the non-conforming use, I have no issue with at all. I mean, they've been doing it for 100 years, and that's, as far as I'm concerned, fine. And
Be of both the church and the rectory.
well, I think they are using the rectory, are they not?
That is my understanding.
I mean, they're using it as a rectory. So, you know, if the property is divided, then I would find that the church and rectory can continue on as certainly as a non-conforming use, and I might have misread this. I didn't think the church and the rectory were part of the RTA.
I do not believe they are within the RTA.
Right. So I don't think that needs resolution. But if the church and the rectory are within the RTA, I don't think they're in the RTA. I don't.
And in the overall request, they asked that we confirm that the proposed building addition is outside the RTA and that the RTA regulations do not apply to the proposed addition, existing buildings, or modified parking. So I guess this applies to the entire property. That would be all the existing buildings. But we'll get to that when we get to lot 2. I also asked for a determination that the non-conforming joint use parking is adequate for the existing church and rectory.
Well, once again, I don't have any problems with the church and the rectory continuing on unabated, regardless of the what might be the technical requirements.
Okay,
So that's where I would view on that issue.
Mr. Sampson?
Yeah, I'm not sure that I follow the way that we're doing it, and that's just on me. I looked at it more broadly, so I'm probably missing some of this nuance as you're discussing it. What I was prepared to look at, and I'll try to peel it back. Sounds like we're focusing only on right now if the current use, or at least existing use, whether it's used for it or not, could continue. We're not yet considering the proposed use. Is that correct?
Correct. And the way I was looking at it was these buildings, regardless of how they're used, have been there nearly 100 years, well before zoning. And to bring them into compliance, just to continue to exist, requires some zoning relief or a finding or a finding of a legitimate non-conforming use.
Assuming we agree, so from there to pivot, if we all agree that it's a non-conforming use right now, because I think we have to, then that goes to, at some point, we have to consider the proposed use. And as we continue the analysis under the non-conforming use, we have to make a determination whether it's unique, and then there's other relief attached to that. Am I correct in how I'm viewing it?
I don't think uniqueness is part of non-conforming use.
Okay.
I think as to the variance relief, uniqueness and practical difficulty are elements.
Okay, so let me step, I guess, to the side then. In terms of looking at the current use, I agree it's non-conforming use. I'm prepared at some point to address the proposed use and agree with the proposed use. I don't know if either of you are going to agree when we get there or when we get there. So I'm just struggling in these pieces. So I don't have anything else to add right now. I agree it's a non-conforming use. I think that's all you've gotten to so far.
Well, part of what brought this to us is the desire for the church to divide the property into two parcels, which we don't do. I mean, that goes to the subdivision process, but they would need the variances for the existing buildings to be able to subdivide at any time. The testimony we heard was that the church uses the sanctuary building, the rectory building, and the church hall at this time. And there's variance relief asked for lot 1, which is the church and rectory. And there is other relief asked for lot 2, where all the new use is proposed. And there are also zoning variances on lot 2.
Mm-hmm.
And just from my personal perspective on property rights is that any property owner should have the ability to sell their property. And in this case, that requires some zoning relief so they can get subdivision approval. I think it's a public policy that the courts have embraced forever, is the free alienability of land. And that affects my thinking as to granting the non-conforming use, the variance relief for all the existing buildings and uses. And I can catalog them when we get a little further along. Let's talk about the proposed use, all of which is on lot 2, and that is to take the abandoned school building, add a new entrance, and convert it to transitional housing for victims of domestic violence. What are your thoughts, Mr. Evans?
Well, I feel myself drifting into the minority again. I would vote against the proposed use. Even though, as a matter of my own sensibilities, I support the use entirely. I also am quite impressed with the Family Crisis Center presentation. I view it as a very sound and stable and well-functioning entity that is serves an important public purpose. I was impressed with their presentation, frankly. And if it were up to me, I would, well, I guess it sort of is up to me, but I mean, as I say, I endorse the Family Crisis Center. I also think actually that the Family Crisis Center, if it were permitted to follow through with this proposal, may be a stabilizing influence on the neighborhood. It's not clear to me that that's true, but it's certainly possible. I got stuck in two areas, frankly. And one area has to do with the definition of a community care center in the BCZR. And as we know, it requires that it be licensed, and the word is licensed, by 2 state agencies, which no longer function in that capacity, if at all. And I could possibly live with the notion that the functions that the original 2 state agencies that were cited in there, that their actual functions were transferred to other state agencies. I could maybe live with that. But the word that I keep going back to is the word licensed, because that is the word in the BCZR. And licensed means, I think, licensed. So I read this as requiring licensing by a state agency. And I did some extracurricular looking online at what this all means for the governor's office. And the governor's office does certify groups, but the certification is, I mean, a group can act, you can have a community care facility without it being certified by the state of Maryland. All that the certification means is that, you know, the state can supply some resources and some funds and whatever, but the state doesn't prevent the facility from operating if all other things being equal. So I don't think, honestly, I don't think that the BCZR conforms with, and this is a problem we encounter over and over and over again. I don't think it conforms with present reality. And, you know, there's a lot of interpreting we can do, and I'm not averse to interpreting a lot of things. I'm not a literalist typically, but I don't know how to get around the word license, frankly. And so that is sort of point number one for me. I just think it has to be licensed, and it's not, and it can't be, and there isn't any licensing that's going on, and therefore it doesn't fit the statutory definition.
Well, it's taking that argument, isn't it? Would you then say that there is no permitted use under the Baltimore County zoning regulations in any zone for a community care center?
Apparently I would. If that's the logical conclusion of the use of that language, then I guess I would have to ultimately accept that position. Now, Yes, I guess I would.
Well, then my next question is, based on your independent research, is this program, is the language creating this program under state law one that would make us preempt? Is it preemptive?
Is the state law preemptive?
Preemptive of the county zoning?
No,
Okay. Just want to
No,
make
no.
sure.
no, I don't think so. I mean, no, not in the slightest.
If the state law mandates a program and the county, the language of the county law doesn't permit it in any zone, that leaves the county non-compliant. So I just trying to look
I hear what you're saying, but I don't, I think that it's just a little bit too much fudging for us to do.
I think so too. And I think the language of the state laws says temporary housing without defining it.
Right.
And I think that the Family Crisis Center currently provides temporary housing, not
Yes, it does.
transitional housing that's of a longer term.
Right.
Okay.
Let me add one other comment. Madam Chair, you indicated your personal outlook on the alienability of the free alienability of property. And of course, everyone in this country believes in the free alienability of property. It's just questions of when there are limitations on that. St. Rita's couldn't have a toxic waste dump there. That would be a restriction on its alienability.
I disagree. That would be a restriction on its use.
On its use, yes, but it couldn't sell its property for that use. Okay, there are use restrictions that are rational in the world. I have I don't want to call it a bias. I have a predilection, I guess, in favor, or that tilts towards communities having a strong say in what kind of uses go on in its community. And this particular area of Dundalk is, I think they view themselves probably correctly as beleaguered and besieged. I want to add parenthetically that I didn't care for a lot of the remarks that the protestants made. I thought they were inappropriate and untoward and unfair towards us and towards our function. But that isn't, really ultimately relevant here. What I do see is a small, tightly knit neighborhood that doesn't want a public program, essentially a public program in its midst. And I get that. I do, I get that. And someone said they wouldn't let this happen in Hunt Valley or Glendon or wherever. I mean, I think that's absolutely true. This wouldn't happen in Hunt Valley or Glendon. And I think that the ultimate use, as much as I support the Family Crisis Center, and I actually know some of the people who have associations with the Family Crisis Center, people I have immense respect for. I think it is ultimately, at the end of the day, a discordant use under Schultz. And I think that the level of community opposition is something which the Board of Appeals needs to respect. And I think it bears on whether this is a uh, whether this is generally in accord with the public interest of the public welfare. And I come out on it being not at the end of the
Mr.
day.
Sampson,
Well, there's a couple points there. With regard to the language regarding license, I take it, I know Mr. Evans is fully prepared, goes beyond what I think is even expected of board members, doing his independent research and such. So I'm certain he read the closing memorandum submitted by Mr. Gontram that attempts to address the point on the licensure requirement. And I think maybe Mr. Evans even broadly made a reference to it, how maybe these responsibilities of certain government agencies at the time had been consumed by some other agency. But I just want to confirm, you have read Mr. Gontram's argument on how to get around licensure and reject that, correct, Mr. Evans?
I have read it 3 or 4 times, and I read the cases. And as I say, if we were simply being asked to, follow the functions of various state agencies as it morphed into different state agencies, I'd be a little more sympathetic to this. The fact that DHMH doesn't exist anymore, but its function is carried on by some other state agency, that I could live with that. I could live with the simple name changes as long as the state function was the same. But here, the problem, I think the overwhelming problem, as I said before, is simply the word license, and the fact that it requires licensure, not simply ratification. It requires licensure,
and not
that I don't think was satisfactorily addressed in Mr. Gontram's memo.
And even for you, government oversight would still not suffice. It's not a matter of being sufficient. It's a matter of a requirement for licensure, and that's just not required here. I mean, it's not present here.
It's not present, and that's the word license to me is a very it's a tough word, and
well, I find you persuasive.
That's where I am.
I find you persuasive on that point. I'm wrestling with this as I do with a number of these things. I did come into this prepared, and I don't know where the chair is going, but I came into this prepared to agree that the presumption is that this use fits into the legislative scheme for residential use, absent a showing that there is some specific condition of the site which exacerbates the impact of such use to the detriment of the public health, safety, and welfare. I'm willing, though, we'll put a pin in that licensure part. I'm persuaded, though, but it's clearly a matter of great debate, and in some instances, passionate debate. I believe that the Protestants did not make any such showing, but I recognize the arguments made. I view this provision of critical services to abuse victims as a benefit to a community and to the health and safety and welfare of the community. I recognize, again, to be redundant, that's not shared, and that's subject to debate. But I'm more comfortable going in that direction for that reason than I am going against what you've highlighted as the requirement for a license. I do think that has a very specific meaning. That doesn't just mean the government might drop in and take a peek here. It means that there's an application process and criteria to be met. And I'm very troubled just in my time on this board, and I say this regularly. admitting that I did not practice this area of law. I did sit on the planning board for 3 years. It is such a unique area of law, and often the cases such as this, I won't say these are the most often cases that come before the board, but these prior uses, then there's statutory enactments or stuff is codified, and it creates one set of issues. Then it seems as though our society is more rapidly moving in a direction that the laws don't evolve to accommodate. And so through all that gibberish, what I'm saying is I do want to find that this crisis center should be permitted at this site. But until I hear from the chair, I am candidly admitting I find myself pulled in your direction, hung up on that requirement. And at this point, I would go against where I was prepared to go.
Well, my view, and let me start by saying, whoever said the measure of a society can be found in how it treats its most vulnerable members just never dealt in Baltimore County. I don't think the use community care center is a permitted use. If the definition had said, or such successor program as may be enacted, and we could fold it under the existing state law, yeah, I could get there. But I don't get there for reasons not unlike Mr. Evans, but it's just an impossible definition to apply to any use in Baltimore County in any zone. So I found the arguments about the RC zone sort of, it's not a permitted use. It doesn't matter where. Having said that, what the applicant is asking for is an increase in density that would not be permitted in the zone. So it's really a use variance, and we don't grant use variances. I happen to agree with both of you that the use would not be detrimental. You've got DR16 zoning across the street. And I am sure in my heart of hearts that many of the residents that would be occupying this use, were it permitted, would be indistinguishable from the residents living in the apartments across the street. But I don't see where the use is a permitted use, and that it could, and that we can grant it purely on the law. So I'm going to agree with Mr. Evans
And Mr. Sampson.
and Mr. Sampson. Though in my heart of hearts, I think it is entirely appropriate for the site. You've got a building that's been abandoned for 15 years. It's an attractive nuisance in other ways. You got it. I mean, for all the reasons that were given, it makes sense. But I don't think it's legal.
Yeah, I had one other sort of, again, point on that same topic. I was actually impressed with the amount of police calls for domestic abuse that come from Dundalk. I mean, and that's sad. That's very, very sad. And it makes the Family Crisis Center actually a tad bit more community oriented than it would be if it were at a different location in the county. But you know, I offer that just as a sort of sidebar comment.
I don't disagree.
Yeah.
But having dealt with the proposed use, we still have some variances on lot 2 to consider for the existing buildings. Those would be,
Let me ask this, if we deny the request for the proposed use, doesn't that moot out all the variance requests? Because it can't be subdivided then, or it's not gonna be subdivided?
well, no, these are
No.
existing buildings. And to bring them in I believe that the petitioner has the right to ask for the variances and RTA relief to bring their site into conformity with current zoning, just because they can, and it would allow them some flexibility going forward.
Okay, I hear you.
And I think that is a separate issue from the use. At least the way I look at it. And the relief was asked separately. The special exception,
If we, just a quick question, if we denied the variances, what would that mean? Would that mean that they would have to tear buildings down?
technically, it means they would have to move them back to conform. Technically, if somebody complained. And I think that would be a practical difficulty.
I'm not prepared to impose that burden on anyone, no.
And those variances on lot 2. Well, the first variance that was requested was for the new entrance on Dunglow Road, and that we would deny because that is directly related to the change in use. The second variance was to permit a street corner side yard setback from Mornington Road for the existing condition, which is the church hall. I would grant that. The third was to permit a rear yard setback from Dunleer Road, also for the existing school building. I would permit that. The fourth was for a parking setback from a right-of-way line for existing parking. I would also grant that. There's some problematic questions though, because they relate to the reconfiguration of the parking. And that is directly tied to the proposed use. So my inclination would be to deny them for the conditions relating to the proposed use, but not to the existing use. That's kind of splitting hairs, but I think it is appropriate for us to allow these buildings to conform by granting variance and RTA relief for existing buildings and conditions. I don't see that it harms the community in any way. I think it allows the church the ability to focus on how to adaptively reuse its buildings in some permitted way, or to find legislative or zoning relief by a change in zoning or a change in the law, neither of which is before us. That's the way I look at the zoning relief on lot 2. And on lot 1, I would be looking at, if you look at the 7 variances that were requested, the first 6, well, 1, 2, 3, 4, and 6 all relate to existing conditions. 5 is again to permit reconfigured parking as a variance for a reduced number of parking spaces for joint use. Again, my view is that to the extent it supports a non-permitted use, that is the community care center, we can't grant it, though the existing condition, I think, should be allowed the relief. And their last variance was from residential transition area to allow reconfigured parking within the RTA buffer and setback. And again, to the extent they're reconfiguring it for a use we're denying, I don't think we can grant that, just relief to allow existing conditions. And then the zoning special hearing. Dealt with relief from the residential transition area for proposed uses, which we would deny, but for existing buildings, which we would grant. The non-conforming use for the church and rectory, which we agreed on. For rooming or boarding house, which we would deny, and then a parking determination on lot 1 that the non-conforming joint use parking is adequate for the existing church and rectory. And I think the existing parking is, as a non-conforming use, should be allowed to remain without the joint use element.
I concur with all that.
Same.
Well, I think we've addressed the special hearing, the variances, to the extent we're granting them, and the zoning special exception, which we are denying. Is there any other consideration that we may have missed?
Not from me, except to say that I find this to be a very unhappy case.
I have to agree with that. Mr. Sampson?
Yes, I do not have anything else to add. Thank you for sharing this.
Yes, that you did actually, I want to make a special comment. You did a great job chairing a most difficult case.
Well, thank you both for that. I hope that moving forward, the county agencies and the county council look at this situation and correct it. There's a huge need. And it cries for attention. And sadly, it's just beyond what we can do. So thank you for your being so thoughtful and invested in this. I think we all agree. So I'm going to conclude this deliberation and go off the record, and see you at the next one. Have a great day.
And also council did, for both sides, did a very, very, very good job. And I want to make sure that's clear too.
I couldn't agree with you more.
All right,
Well,
good day,
thank you.
everyone.
Okay,
Bye.
Have a good day.
thank you. Bye-bye.